Let's then begin. Today is the 21st of October. This is the monthly board meeting of the State Board of Education. Let's go through with introductions. Let's begin with Sabina.
Sabina Brochu of Williston, student member.
Dan?
Good morning, Dan French, Secretary of Education.
Kim? Kim?
Okay. Sorry, Kim Gleason, Essex.
Yes, good. Thank you, Kim.
Connection problems.
Kathy?
Kathy Lavoie from Swanton.
Bill?
Bill Mathis from Goshen.
Jenna?
Jenna O'Farrell, St. Johnsbury.
Oliver?
Oliver Olson from Londonderry.
Peter? I don't see Peter. Anelita?
Anelita Pena from Moncton.
And Jennifer? I think you're muted, Jennifer.
Good morning, Jennifer Samuelson from Winhall.
Good morning to you all, and thank you again, and I apologize for being late. Just a reminder about our guidelines. You are on TV, quote unquote, almost quite literally, and every moment is being recorded, and in some cases being seen and heard by others simultaneously or offline. Please remember that any background noise is at your end, dog, bell chiming, any of that sort of thing, or my end is very distractive. So as a general rule, stay muted unless you know that you're going to want to jump into the conversation. And when you mute yourself, then like me, try to remember to unmute when it's needed. If you wish to speak, either raise your hand in the ordinary way that we do things, or use the hand icon that's available in the bar at the bottom of the screen. And then finally, please address your comments to the chair, as is customary. So let's go on to the consent agenda. The consent agenda to this month consists of only two things: the minutes of the 16 September meeting of the board, which you have received, and also a notice of the closure of an approved tutorial. Is there any discussion of the items on the consent agenda? Any corrections to the minutes necessary? Hearing none, then, is there a motion with regard to the consent agenda?
Mr. Chairman, I'll move.
It has been moved that we accept the consent agenda as presented.
Second.
And it has been seconded by Mr. Mathis. All those in favor indicate by saying aye.
Aye.
Aye. Opposed? The ayes have it. The motion carries. You've approved the consent agenda. Board announcements. Are there announcements from, we'll get to the student announcements or comments or momentarily, but general board announcements, are there any? All right, hearing none, we welcome comments and introductions by student members. In order of seniority, we'll start with you, Sabina.
Hi, thank you. So originally the plan was to present you guys with some data that the student network had collected, but we had been collecting data up until, I'm pretty sure, Friday of last week. And so there was little time to analyze it and put it in a nice format to share with you guys. And so I want data to be received in a way which it'll be most beneficial. So Anulita and I are going to postpone sharing that with you guys till next meeting, and I'll reach out to you, John, to request a little more time so that we can really dig through all of the data that we received. But I think otherwise than that, there's been a lot of positive work with the student network, and I'm really happy with what we've done, and I'm really excited to show you guys the first kind of big project that we've put together.
I think we are perhaps equally excited to receive it. I think this will be great fun to hear what the two of you have come up with. Do you want to tell us a little bit about what's happening at your school, Sabina?
Sure. I think we've kind of fallen into a groove of what's happening, and so it seems like we're very used to going on your 2 days, and when you get there, there's everyone kind of where they're supposed to be or what they're supposed to be doing. And I think that's good. There is almost, I guess, a sense of normalcy in the sense of it doesn't feel too weird as it did to begin with. And, everyone kind of is there for each other. And a lot of, at least at CVU, there's a great community of people who, support each other. And even walking through the halls, you'll see people, you'll say hi, or if you're just sitting down, like teachers are really good about just checking in and being like, hey, what's up? How are you doing? And really, a genuine, like, how are you doing? Because, mental health is a huge issue now, especially. And so I think that is a great thing that I've seen, is that there definitely has been a lot more awareness towards students' mental health at CVU.
Good, great. Angelita, how are things at your school?
Pretty good. Yeah, I have to kind of agree with Sabina. My school has basically been doing the same thing. I would argue that the community has grown a lot closer to the fact that we can't go out and do stuff like that, and it has become a lot more normal. I would argue that there are a few things that could be fixed at my school. Frequent hand sanitation, still kind of an issue, and we have all those little mini issues, but Sabina is going to share a majority of that in her next presentation, so I'll hold that off. And yeah, I have nothing more to add aside from what Sabina has shared.
Great, good. Thank you both. So I'll hear from you, Sabina and or Angelita, about your presentation at our next board meeting, and we'll I would maybe touch base with me in the next week or so that I know what you folks have in mind, because Dan and his staff and I meet at about 10 days out from this meeting. In other words, just before the end of the month. So to plan the meetings. Very good. It's now time to hear from the public. Suzanne, do you see anybody queued up who wishes to speak to us?
I do know that there is one gentleman, and I do see that he is on right now. His name is Mr. Kramer.
Good. Then let us proceed to hear from, and do we see anybody else, Suzanne?
John, I do see others, but no one let me know that they wish to speak.
Okay, so any of you who are listening or watching and wish to speak, please immediately communicate with Suzanne, Suzanne Sprague, who's administering this meeting for us, and indicate to her if you wish to speak. Otherwise, Mr. Kramer will get more time than he might have expected. Mr. Kramer, let's give it 5 minutes.
Sure.
How does that sound?
Sure. Yeah, that's fine. I may not even need it, although sometimes I can be known to go on longer than I was supposed to. I am the co-chair of the Friends of Cornwall School group here in Cornwall, Vermont, which is, essentially our PTA type group. And I've also been involved in the last year and a half or so in discussions around potential school consolidation. We are part of the Addison Central School District, and we have 7 elementary schools in our town. Prior to our merger in 2016 into a unified union district, we operated jointly with the other 6 schools, a middle and high school in Middlebury, and that was its own union district even before we became a unified union district. And that has gone quite well, and I think most folks are happy with that situation. When we voted to merge into a unified union district, there was some discussion around the question of school closure. And I think we were sort of under the impression, at least I was, that that was not really the focus of merging into a unified union district, but rather that we would seek other ways as a unified union district to address efficiency and equity. Unfortunately, it seems that post-merger, the discussion moved pretty quickly toward school closure. A consultant was hired to review the buildings and facilities within our district, and has now come out with recommendations this year to close 4 of the 7 schools, so a majority of those in our district. We, in the meantime, some of us who've been involved in the issue have tried to petition. We're one of a handful of unified union districts that does not have a provision in our Articles of Agreement that would require a vote of a town to approve prior to the closure of a school. We petitioned the board and to potentially warn to the voters a change to our articles that would have inserted that requirement. And unfortunately, the board chose not to warn that to the voters. So that was actually, I believe, a decision made earlier this year. It gets a little fuzzy with COVID. So that's kind of where things stand. And the board has indicated in terms of timeline that the hope is to draft a plan that would involve closure of a majority of our elementary schools by, not the closure, but the writing of the plan by the end of this year, calendar year, and then to vote on that plan by town meeting day, which wouldn't really give us much time to say, take other routes like elections to try to address this issue. So unfortunately, I think those of us who would like to focus more on the other benefits of being part of a unified union district, we were a voluntary merger. In fact, I think we were the earliest in the state, but it's certainly among them. We are looking at the possibility of withdrawal. The 4 towns that are slated to have their schools closed are looking at that. We're a funny animal in that sense because we actually would rather not. I think that there are, well, I shouldn't speak for everyone, but I think the general feeling among the folks that I'm engaged with is it's not really that we don't want to be part of a unified union structure. We voted early to go ahead with it. It's just that we feel that Act 46 was pretty clear that its intent was not to close small schools. If you look at Section 3, as I'm sure you're all intimately aware of. Oh, sure.
I have to interrupt you for a moment. Suzanne, any other public indicating an interest to be heard?
No, John.
Thank you. You may continue another 5 minutes, Mr. Kramer, and then we'll wrap it up.
Okay. So in any case, that's where we are. We do have a petition to move forward with withdrawal here in Cornwall. There's one in Ripton that's before their select board now. Ours has gathered sufficient signatures, but it's not in front of our select board yet. And then there are 2 other towns, Shoreham and Weybridge, that are exploring this possibility, but are not quite there yet. So that's where things stand. I think the reason I wanted to come on today is we're aware of some of the discussions around Reedsboro and Halifax that occurred at the August and September SBE meetings. And we know that withdrawal is quite the process. We would need an approval here in our own town. We would then need a vote of the other 6 towns, as would all of the other towns that are looking at this. And only then would we kind of get to the SBE. So if we're going to go forward with it, we'd like ideally to have some clarity around is it worth the effort? And is there going to end up being a lot of subjectivity in the end around that approval process, which would be sort of a third level of approval? Right now, we understand that the statute's pretty clear in terms of how it works, but we also understand that there's some concern that not addressing withdrawal may have been an oversight in the drafting of Act 46. So we would just request that if there's an effort to suggest to the legislature a change to that statute, that it at least be done in a way that continues to make it pretty clear what the standards are, because I think our concern is going forward with our town and then all the other local towns in the district, and then getting to that third level. If we've gone through all that, and then it's sort of a subjective process, it weights it very differently for us than as things stand right now. So that would be our request. We understand from the chair that the decision that was made around Halifax in particular was not so much around substantive review of their sustainability, but rather whether students would have a school to go to. And that's fine with us if it stays that way. But if it's going to expand beyond that, I think our request would be that it simply trigger a substantive review of the educational quality standards under Section 165, because that's laid out pretty clearly, and we would feel like we could judge that. If it becomes more subjective than that, then it does start to potentially change our calculation. So I think that would be our request.
Very good. Thank you. Oliver, you have a comment? Oliver, you're muted. We need to have you on mute.
Sorry about that.
Okay.
So thank you, Mr. Kramer, for your very thoughtful comments and approach to this. So just a couple of quick things, as I think that the chair had previously indicated, the legislature gives us the parameters from which we have to work within. So I think, the sense of the board is simply that, we need the legislature to tell us how they want us to operate. We're not proffering a specific recommendation. But I will point back to the original goals of Act 46 and the parameters. And if you're looking to sort of divine some guidance, I think that would be a good place to start, because that was a subject of quite a bit of litigation, as I'm sure you know, that was upheld by the Supreme Court. And it very clearly dealt with the premise that what the preferred structure is. So I think it's fair to say over time there will be movement of districts from, say, one unified district to another. But I think, the spirit of Act 46 was to create larger governance structures, not smaller governance structures. So I would just encourage you to think about that. And then the final thing is, if your real concern is about the closure of a school, another avenue that you may want to pursue, because it sounds like your issue isn't with the governance structure, it's with the closure of the school. You could petition the new district to look at revising the articles of agreement to provide some protections, and that might be a way to really address the core issue you're concerned about. So I'll leave it at that.
Very good. Thank you, Oliver.
Mr. Chair, I don't know if there's a moment to respond quickly or not.
Let me just point out to Oliver that indeed the communities did petition their new district for provisions such as this, and for some reason the board never put that to a vote. So it was died a morning. That's the point you wish to make, Mr. Kramer?
That was one of the only other one actually is just to confirm. As I say, we're a funny animal. I think we'd actually prefer to stay unified union district. That may not be true for all that are looking to withdraw, but as you say, that's not our issue. We actually like being part of the structure, and as you say, Mr. Chair, we did. The reason that was given for not warning it was that the articles around school closure were seen by council to the board and the district as being within the purview of the board and not the electorate, so that the board could choose to warn it to voters, but was not required to. There was some discussion at a board meeting as to whether to go forward with that warning, and it was decided to keep that authority within the purview of the board and not warn that to voters.
Okay, thank you. Bill Mathis, you have a comment? Have to unmute, please.
Yes, could you go further with this? They having a petition which they chose not to put on the agenda. I didn't think that they had a choice in those matters.
Mr. Kramer, do you want to respond?
Sure. So generally, there isn't, but as I said, in this case, there was a legal opinion which was written, so I could, and it's public, so I'd be happy to forward that if that's helpful. It could explain the rationale. But essentially, the legal opinion said that for this petition, because the subject matter of the petition fell within the purview of the authorities reserved to the board and not to the electorate, that in that particular case, the board had discretion. It wasn't that they couldn't warn it or shouldn't warn it, but that they could choose whether to warn it or not, because it was their area of authority and not the electorate's, and they chose not to do so.
For what it's worth, I believe that in Harwood district, a similar initiative was pursued, and a similar advice of counsel was received. Bill, will you take down your hand icon just so I know that you're not waiting? So thank you, Mr. Kramer, for this. I would suggest you listen to the next 10 or 15 minutes, which is the chair's report, at which I am going to speak further about this particular topic. So that is the end of the public.
Excuse me, John?
Yes.
This is Suzanne. We do have somebody else that wishes to speak. Her name is Kim Daughtry, and
that is Kim Daughtry. She is the attorney for, I believe she's the attorney for the plaintiffs who are former students of the Kernhattan homes. I would just say that we would take up what Ms. Daughtry has to say at the time scheduled on the agenda. And beside that, we are at the end of the public comment period. So if you would relay to Ms. Daughtry that she will have an opportunity to address the board in item H, that would be great. Thank you. So board members, this is now item E, the chair's report. And I want to, I did send to you last night the draft of our proposed communication to the legislature. However, I inadvertently used an old distribution, and so I believe that neither Jennifer nor Anelita received this draft, for which I apologize to you both. I did an old man brain cramp and used an old distribution list. So I'm going to take the liberty here of reading to you the draft, although those of you who are attentive and assiduous have already read it, and I apologize for that.
Mr. Chair, I didn't receive it either.
Oh, okay, pardon. Then all the more good reason to, nor you, Kim.
No.
Oh my, all right, then I really messed up and I apologize. This is, so the memo said that thanks to Oliver for a first draft, I developed a final draft of a communication to the General Assembly, per your direction at our last meeting. You'll recall when we were done with the Halifax matter, you all said, gee, you know, this is pretty awkward and pretty unsatisfactory. And we wonder if the General Assembly is aware of this provision in statute 721A that allows dissolution of districts and withdrawal, and whether that really squares with the General Assembly's intent in Act 46. And so you all said, please compose a communication to the General Assembly to bring this matter to their attention. So the draft I'm going to read to you proposes to do that. Dear Representative Webb and Senator Baruch, they being the current chairs of the two committees of oversight, at its 16 September 2020 meeting, the Vermont State Board of Education considered a request from the town of Halifax to withdraw from the Southern Valley Unified Union District. Such a withdrawal is provided by statute at 16 VSA 721A. Based on a plain reading of the statute and advice of counsel, the board concluded in its review that the scope of its inquiry in this matter was strictly limited. Quote, if the state board finds that the students in the withdrawing member will attend a school that is in compliance with the rules adopted by the board pertaining to educational programs, then the state board shall declare the membership of the withdrawing member in the union district to end. That's 16 VSC 721 sub C, 721A sub C. At its hearing on the matter, the board received testimony which gave assurance that, quote, the students in the withdrawing member will attend a school that is in compliance with the rules adopted by the board, unquote, and accordingly granted Halifax's request to withdraw from the Southern Valley Unified Union District. Because Southern Valley is a two-member district, Reedsboro and Halifax, the board's order effectively dismantles the district, which was created under Act 46, leaving both towns to fend for themselves as individual members of the Wyndham Southwest Supervisory Union. Throughout these proceedings, the board found itself without statutory authorization to consider other dimensions of or possible consequences of the Halifax withdrawal. For example, the board was not permitted by statute to consider the impacts of the district's dissolution upon the schooling of Reedsboro students. Similarly, the board was not authorized to take into account the purposes and goals of more recent legislative initiatives, most particularly Act 46. Accordingly, the state board has directed me to convey to you its concerns with 16 VSA 721A, along with the suggestion that the General Assembly may wish to reconcile the provisions of 721A with the legislature's more recent policy goals on school governance, i.e., Act 46, signed by me. So that's the message I felt that we together framed, that we just felt so constrained by the very limited language of 721A, and we wondered if possibly the legislature wanted to revisit this matter. Any comments, please? I see Oliver signaling a thumbs up. Any other comments? Yes, Jennifer, please.
I think that was very well articulated, and thank you and Oliver for taking the time to draft that.
Thank you. By the way, I see, let's see, any other comments? No. All right. Thank you then. Well, then I'll take that as an affirmation that this letter does the job. I think one of the concerns that the Mr. Kramer had expressed was a concern that possibly our communication about this would be mixed in with other legislative proposals. And of course, we will be going to the General Assembly for sure in January to renew our initiative with regard to clarifying the different roles between the State Board and the Agency of Education, all of which we had started last January, gotten through the Senate, and then the wheels came off in the legislature, and nothing but really pressing and large issues moved further. And so we will have to go back to square one with that legislative proposal, but that would be totally separate and apart from this matter here. My guess is that there may be, before we are done this year, you may have some other ideas about legislative proposals that, or legislative matters that we might bring to the attention of the General Assembly. But for now, this is a standalone recommendation to the General Assembly, and I will send it off with your blessings forthwith. That's the end of the chair's comments. Are there any comments on those comments? All right. Hearing none, then we're happy to hear from you, Mr. Secretary.
Yeah, good morning. I'll just confine my report to COVID-19 related issues and give you the opportunity to ask me any questions in that regard. Our health guidance for reopening schools has been our primary guidance document. That document's going through a revision this month. I expect we'll be issuing an update to it here within the week. Not significant changes being contemplated, but just more or less adapting to conditions and also additional science and the research and our experience dealing with the virus. On a related guidance issue, we will be promulgating guidance for winter sports, also probably within a week as well. So that's something we're working on, have been working on for some time. We have a separate group that's associated with that work. And I think, just lastly, I'll just make the observation that I think things are going fairly well. Our schools really stepped up and, really struggling with implementing fairly complex logistical and health considerations in order to operate schools safely. That's as much as that's sort of been achieved, if you will, the reopening. It's an ongoing effort. And we speak increasingly about schools needing to be able to operate in this context for the remaining part of the school year. Even though a vaccine might become available, it's unlikely that the implementation of vaccine would be at such a level that it would allow us to walk back some of our other mitigation strategies like wearing masks and so forth. So that being said, I think, we're a bit anxious now about the travel. That's clearly emerging as a consideration that wasn't necessarily elevated to a primary concern for school district operations. You'll see in our new guidance that has been included more prominently, particularly as we approach the holiday period. We're interested in encouraging, certainly through communications, that Vermonters be safe during the holiday period, but we're also considering what other steps we might need to take relative to the holiday travel to ensure our schools can continually operate in a safe manner. So I think, that's pretty much it from a COVID perspective. I'll end my comments there, and if there's any questions, I'd be happy to try to address them.
Thank you, Mr. Secretary. Board members, do you have comments or questions of the Secretary?
Yes.
Bill, Mr. Mathis?
I'm the Secretary, the Federal Secretary of Education came out with some guidance, or I don't know if you'd call it guidance, but just saying that basically there will not be any waivers to assessment regardless of the chaos that's going on and the huge demands that people are under. Have you folks looked at that, and do you anticipate any kind of change, or is that to be seen? Where are we?
Yeah, I mean, we're having those conversations at the national level among my peers in the country. I think the consensus right now is there's concern, and that we'll put our energies more on this topic after the election.
Thank you.
Doesn't really surprise me, I suppose.
Thank you, Bill. Any other comments or questions for the Secretary? All right, then, hearing none, we're happily ahead of schedule. And if Attorney Simmons is, I see she's standing by. Thank you, Emily. We're ready for you to go with item G, if you're prepared.
Sure. Good morning. Emily Simmons, General Counsel for the Agency of Education. My understanding is that you had questions about the state board rule for the approval of post-secondary institutions. So I've reviewed those rules. It also is a happy coincidence that you all were reviewing your rules generally for another item on today's agenda. So rather than, I didn't know what general information you were wondering about, I wanted to make myself available to answer your questions about that process. In order to get us started, I'll give you a brief overview to prime the pump for this conversation. Recall that in order to operate a degree granting institution either in Vermont or out of Vermont that operates in Vermont and meets the standards, an institution has to be reviewed by the Agency of Education and sent to the state board similar to an approved independent school to receive a vote of the board whether the board accepts the recommendation of the agency that the school ought to receive a certificate of approval and then a certificate of degree granting authority. Those are two certificates that an institution has to have in order to operate in Vermont or to offer credit inside of Vermont, although it operates and is chartered outside of the state.
And there is also statute that applies in addition to our rules, yes? Presumably
and
our rules reflect the statute.
Exactly.
Yeah, yeah. So it is quite clear that the board, Emily's comparison to our approval of independent schools is apt, although it seems to me that in the case of independent schools, both the statute and our rules are fairly explicit about the conditions of approval. In the case of post-secondary schools chartered in Vermont, the conditions for approval are, at least in statute, are comparatively general, I guess I would say. Is that a fair characterization, Emily?
Well, you'll find a good bit more detail in your rule, luckily. So if there are concerns about a lack of specificity, I'd encourage you to look at your rule. Right. And this is also an important time to bring up Rule Series 2200 is where these rules are located. That's a very lengthy rule series, which also includes the approval of independent schools. So when the rules are open, 2200 is open, that will also enable you to make any changes to the post-secondary approval rules that you think are appropriate or necessary.
Right. Thank you. Just to clarify, this was listed in our agenda as having to do with the it says, quote unquote, relicensing of Marlborough College. And frankly, that's perhaps my error in making that reference. This conversation does not relate specifically to anything to do with Marlborough College or what was once Marlborough College. But knowing that there is a possibility that sometime in the future, the current ownership of the property of Marlborough College may choose to apply for to operate a post-secondary school of some sort. I wanted the board to be just up to speed on what our role in that might be. And it is somewhat limited, but it's also pivotal in the sense that should the board not grant approval, then a post-secondary enterprise cannot grant degrees or credits and is really kind of becomes just a fiction without that approval. So that, I think, are there any questions for Emily about either the rule or the statute as it pertains to the board's authorities here? I see, Dan, you have your hand up. Do you have a comment?
Yeah, I was just going to mention, John, as a follow-up to the Marlboro point, there were a couple media reports, and we've received queries about the new owners of Marlboro College. To our knowledge, they have not contacted us yet, so we don't have any information inside the agency about the status of the new owners applying for the ability to operate.
Exactly, thank you. And the statute, I think, requires that is the first step. And they don't start with us, they start with the agency. And it looks very parallel to an independent school seeking to be approved. You begin by communicating with the agency, and the agency does its due diligence and then makes recommendation to us. So it's pretty straightforward. Any other questions or concerns? I think not. Oh, yes, Kim. We're hopeful to hear from you, Kim.
Sorry.
There you are.
There we go. Sorry, the system is quite slow here. So I am just wondering, are there any other places that the State Board of Ed has authority or touches post-secondary? Is this the only place that we have any authority?
The only place.
I believe it is. For instance, you do not have a set of rules and there's no statute on education quality, right? Akin to the education quality standards or the minimum course of study. I can double check for you, Kim, if you want an exhaustive check, but nothing comes to mind.
No, I was just trying to think about it in the context of the list of things it would make sense that we would have authority or not. And if not us, then who, if this were not ours, as we look at divvying up roles and responsibilities?
There is the one that the board will remember, which is to do with records of an institution that's closing.
I do remember that.
Yeah, that's a pretty big responsibility. It's worth noting that in statute, the exemptions to the applicability of the requirement for approval of a post-secondary school, the exemptions to those requirements are pretty long. Exempted from these requirements are virtually every existing secondary name brand secondary school you can, post-secondary institution you can imagine, UVM and state colleges, and then it enumerates a whole bunch of the schools that are so-called accredited and therefore exempt. Bennington, Marlboro was listed there, St. Mike's, Vermont College of Fine Arts, Vermont Law School, Middlebury, Champlain, you name it. Any name brand post-secondary institution that is accredited, I believe, is exempt from the provisions of subchapter 2. So it's mainly going to apply to essentially startups. And Rule 2200 also speaks to distance learning schools and schools that are not domiciled in Vermont, but have some degree of operation in the state. So it's a fairly narrow band of schools. There's no approval/reapproval process. There's no, with regard to these kind of established schools that I just enumerated, there's no provision for approval to be revoked or suspended for those schools because there's no provision for us to approve them. They are exempt because they are accredited. Is that, Emily, do I have that about right?
It sounds right, but I'll give the caveat that I haven't reviewed that question this morning.
You sound like my wife and my daughters. It sounds right, Dad, but I don't think you're right. Okay, good. Any other thoughts or comments about this?
Yes, Mr. Chairman.
Yes.
I'm just wondering is this a token approval or quite the opposite? Is it a wide open door? I think we probably need to go back to the root issue as to whether we should be in the business, and if so, for what purpose.
Would you like to say more about that?
Excuse me?
Would you like to say more about that? What do you have in mind when you say a token issue?
Well, here is a set of rules that we have to implement, and we don't have the staff to do it. And if it's going to be something which is tokenistic or just going through the motions, why should we do that? And therefore, it means we'd have to define what would be okay and perhaps run it through the legislature and then go from there. But it could be a very huge task, and I'm just trying to figure out how big is big.
Comments or responses to, yes, Kim?
I think that was a little bit what I was getting at with my question, was to what extent do we otherwise have any role in this? And if we're just rubber stamping on the rare occasion this comes before us, I just wasn't sure if it were not us, because perhaps if we have no other authority on quality or any other matter regarding these schools, is there some other entity that would be better in the position to have this as their responsibility? That was exactly where I was going with it, Bill.
Mr. Chairman, Mr. Secretary, do you have any thoughts on what you've just heard?
Not especially, other than I just observe we don't have a lot of experience under this framework. I mean, it's only, most of the issues we've been dealing in higher ed are about closure. So this is an area where we don't have a lot of experience, I think. So.
Well, I guess there's maybe two ways you could go in response to Bill and Kim's query. One is either to get really more serious about what we're looking for or what we want, what capabilities we believe a post-secondary school should have. In other words, one could say, well, many of the requirements that we have for approved independent schools ought to apply equally to post-secondary schools as well. Keeping in mind that all the big schools are already exempted from our oversight. The alternative way is to just say, look, we're not adding any value to this. We ought to get out of this entirely, and we ought to simply leave it to the secretary to grant approval without involvement of the state board. I think what you're saying is we either ought to fish or cut bait. We ought to either really get substantively involved in the qualifications of these entities and hold them to a set of standards not unlike those that we do with approved independent schools, or we ought to just back away and say we're adding virtually no value, we're just rubber stamping something done by the agency and petition the legislature to modify the statute that requires our involvement at all. Is that a fair characterization of the choices that we would face? Either get better at this or get out of it. And as Emily said, by the way, we could modify our own rules, but probably given the nature of the language in statute, which is very, very limited, we would not be able to go too far by doing this by rule. If we wanted to strengthen the criteria for approval of post-secondary schools, we would probably need to go to the General Assembly and ask them to do so. Otherwise, we're getting in the tiptoeing very close to the edge of intruding upon legislative authority. Jennifer, you had a comment, a question.
Yeah, I'm curious with regard to the independent schools, what level of continuing oversight do we have over them?
Pretty substantial. Should there be any departure, we grant an approval based upon a series of criteria. The criteria are elaborated in some degree in statute and then elaborated further in rule. I might say the General Assembly remains attentive to this matter. It made some changes only a year and a half, 2 years ago in our authority to examine financial capacity and even to appoint a visiting committee to examine that issue. And there are rule changes. The Act 173 makes further changes in the rules for approved independent schools. So I think it's fair to say that our rules for statute and rules for approved independent schools are fairly comprehensive. Perhaps and we seem to be pretty good at hearing or spotting concerns and opening up reviews of that approval. And if necessary, we have the authority and we are prepared to revoke or suspend an approval, which, by the way, is an item H goes to that very question.
So I'm just curious what the rationale is that there's a list of exemptions at the post-secondary level. Why is there that distinction made between the post-secondary schools and, the K-12, presumably independent schools?
It's a good question. But in partial answer, I can say that there is a parallel in the sense that an approved independent, an independent school that has been accredited by NEASC is therefore by definition, that is sufficient grounds for it to be approved by this board. Now, the statute doesn't say that we must approve it if they are accredited, but it says we may. And the board's custom, as far as I know, has been always to accept accreditation by NEASC as prima facie evidence of compliance with board rules. So in some ways, there's a parallel because the enumerated post-secondary institutions are all accredited. But the language is different. The language in the case of post-secondary says that they are exempt from consideration by the board. The language with regard to approved independent schools, i.e. K through 12 independent schools, says that can substitute for the board's approval. So there could be some, so I don't know why those distinctions are drawn, and it would be worth understanding that better and exploring perhaps with the committees of on education what their appetite for would be for a more assertive set of standards that the board would use with regard to essentially new post-secondary entities. Emily, you have a comment or question?
Just a theory. I see that this section of the statute regarding the approval of post-secondary schools generally was added in 1981. Now, I did not grow up in Vermont, but I do believe that all of those institutions were in operation in 1981. So it might be simple grandfathering.
Yes. Yeah. Although there is reference to accreditation, but you're absolutely right. It could simply be that. So if the board, we can take this up at a later time, but we can go further with this. But if the board decided that it felt like we wanted to muscle up a little bit about what we expect of post-secondary institutions, my guess is that we would need to make the case for that and then bring that to the General Assembly. Because as I said, existing statute is very thin, and were we to apply a lot of conditions not envisioned in the existing statute, we would be running, probably not endearing ourselves to the General Assembly. Bill Mathis, you have a comment?
Yes, you just basically said what I was going to say, is that this is a situation in which we neither fish nor fowl. It's sort of some kind of amalgamation with a whole lot of different reasons underlying it. And I think that if we did go in that direction, we should go to the General Assembly.
Yeah. Thank you. Thank you.
And if it's okay.
Yes, Kim.
I also think we don't necessarily need to find ourselves more work. I think it was a genuine question. If there's no other body that would do this, and we're certainly not seeing a run on a whole bunch of, fake schools trying to domicile here in Vermont because we've got this wide open door for this to happen.
Right.
So it may just in fact be that there is not another authority. I don't think we want to begin to start being in the business of crafting standards for higher ed. I think that's outside of our capacity and our really, where we have standards for our pre-K-12 public schools, it is reasonable that those apply to those independent schools in pre-K-12 that we authorize. Yep. And I think that makes sense. I think it would be outside of our capacity or authority or expertise to find ourselves muscling around that area, but I think it's worth seeing if there's any other entity that otherwise does this work better and makes more sense. But otherwise, it could just stay status quo.
Yeah, it could. And it might be interesting to scan the statutes and rules in other jurisdictions, other states. It could be that we are, in fact, the Bermuda of North America, and but I've never had a sense that we are a haven for people to come and start schools kind of under the radar. But it might be prudent to at least assess that as to whether we have the same kind of barriers to entry that other states do, and then just know, is that okay with us? But I see a lot of heads nodding when you say this is outside our area of expertise, and we do have, it seems like, lots to be attending to. Let us, if you're satisfied with leaving things there, then let us now go to our break. And I would ordinarily limit it to 15 minutes, but I think actually that's what we will do. We will resume at 10:20, and we will take up item H at that time. So mute yourself, take down your video if you are able and willing, so that there's not a lot of empty kitchens and living rooms on the screen. And there you go. I see it happening as we speak. Thank you. See you at 10:20. Thank you. I think we can and must get underway. So we are now at item H on the agenda. Oliver, you have something you want to say.
Yes, Mr. Chair. At this time, I would move that the State Board of Education, pursuant to 1 VSA Section 313, find that premature general public knowledge would place the State Board at a substantial disadvantage, and would further move that the State Board of Education enter into executive session to discuss probable civil litigation to which the public body may be a party.
So moved.
Thank you. It has been moved. Was that a second, Bill?
That was a motion to move, but I'll be glad to second.
Yes, please. Mr. Olson made the motion, and Mr. Mathis is seconding the motion. Kim, did you hear the motion? Thank you. Thank you for joining us.
I did. Yeah, no, I'm sorry. I've got a problem with my computer. I'm going to try and get back on that, but for now, I'm on the phone.
So, board members, just so you know, the passage of this motion requires a 2/3 majority among us. And I'm sorry, Angelita, you and the secretary are unable to vote. So, are you ready for the question?
Yes.
It has been moved and seconded then that the board entered into executive session for the reasons given by the maker of the motion. Those in favor, please raise your hand. 1, 2, 3, 4, 5, 6. It's unanimous. Thank you. The motion passes. We will now go into executive session, and the method for let me begin by saying that the board has just concluded an executive session in which there was a broad discussion among the board members pertaining to item H. The board concluded by consensus that the original matters brought up by the secretary for its concern are indeed concerning to the board, and the board wishes to have an adequate amount of time to consider the secretary's recommendation for review. However, very recently, the board has received communication from other parties which take issue with some of the conclusions and interpretations of the secretary. So it became apparent only very recently that this would become a complex and perhaps contested matter simply on the facts as well as other interests and concerns. And so the board has concluded two things. Number one, that we urgently want to take this matter up. It's more than two things. That we wish to have available to us.
Mr. Chair, sorry to interrupt, but just a slight correction. The board has actually not come to any conclusions yet. We're going to be, at least I intend to offer a motion. So we've had discussion, but we haven't come to any, yeah.
Understood. That the board wishes to take this matter up but at a later time when it has allowed enough time for an adequate discussion among all the parties. And also at a time when the board has available to it legal counsel to guide it in the procedure, so that our procedure is fair to all parties and all interests in the matter. And we do take the secretary's recommendation for review very seriously, and we want to give that recommendation the time and attention and expertise that it deserves at the earliest possible opportunity. So as a consequence of all that, the chair will entertain a motion. Mr. Olson.
Yes, thank you, Mr. Chair. So at this time, I would move that we table this particular agenda time until such time as the board can secure legal counsel and schedule a meeting to take up this matter with sufficient time to address the various issues.
Good, thank you. Is there a second to that motion?
I will second the motion.
Motion has been seconded. The matter before us will be tabled. Is there discussion? Are you ready for the question? Those in favor of the motion to table action on item H to a date to be announced, please indicate by saying aye.
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 Let's raise hands, please. I see it is unanimous. Absent is Mr. Mathis, and of course not voting is the secretary and Ms. Pena. The motion is unanimous and carries. The next item on the agenda is
Excuse me, Chairperson.
Who's
Carol?
speaking? Who's speaking?
Chairperson Carol, this is Kim Doherty. You asked that I defer my public comment until this moment in time. May I have a brief moment to be heard?
Yes, 5 minutes would be fine, Ms. Doherty.
I'll be brief. Thank you very much for the opportunity to be heard. I appreciate Secretary French's recommendation to the board and the board taking this matter very seriously. On behalf of 30
Mr. Chair.
Yeah, go ahead.
And apologies, but I'm since we are tabling this motion and it will be brought up, would council be agreeable to postpone, to deferring those comments until we bring this matter back up? We're not, the matter's not extinguished. It will be coming up at a special meeting.
What I'd like to urge the board to do is to use your authority under 1 VSA Section 310 and call a special meeting on these matters as soon as possible. Delaying this vote is a delay of justice for the survivors and only continues to leave children in the homes of Kernhatten at risk. This is a very serious matter. It needs to be heard immediately. I can tell you the heartbreak that I'm going to hear from every single one of my clients when I have to tell them you deferred this vote. It is a shame. And I urge you to call a special meeting immediately. Thank you.
Thank you, Ms. Doherty. Board, we now move on to agenda item I, SBE rules needing updates. Ms. Simmons, are you nearby? There you are. Would you lead us in this discussion, please?
Sure. Emily Simmons, General Counsel for the Agency of Education. In your packet for this meeting, as well as posted online, is a memorandum from me, which is a chart laying out each of the state board's rule series in the order that they appear on your webpage, with the date that each of the rules is listed as last being revised. That's information that is included on each of your rules at the very bottom, as well as any comments that I had myself that would indicate how to prioritize or how to think about any revisions that the board might undertake, just from a perspective of whether they are currently out of date with other statutes or rules. The chair wrote to you prompting all the members of the board to devote some time to familiarizing yourselves with the content of the rules, but I've also given my summary of content because many of the rules include content that's not indicated by their title alone. So I wanted to highlight some of those issues for you in case you didn't know that some of those issues were in your rules. One editorial comment I'll make to help put all this in context is that the vast majority of your rules give direction to the staff of the Agency of Education. So many folks don't read the rules who don't work at the Agency of Education, and that certainly could apply to board members. Many of the topics you've totally deferred to action by the agency, and so it doesn't come up at any of your regular meetings. These are items that don't land on your agenda, and it's perfectly understandable that board members, who have been on the board for many years, might not be fluent in those rules. But this is an attempt to get the conversation started about how the board would like to organize any work, which will be a big project, to update the rules generally. There's not really a rule series that I could point to that is perfect and without need of update. And as you know, several of your rule series are going to come up for updates because of legislative action. Act 173 is calling for 2 rulemakings, one that you're in the middle of and one that you haven't yet started, but you will soon. So if I can open it up to questions there, I can preview for you. It might make sense for the board to discuss setting up a working group to meet with agency staff who can assist you. Donna Russo-Savage is going to be available to provide some drafting to the board and some research capabilities to the board when you get ready to jump in with both feet on this issue. Of course, it's your agenda setting prerogative and how you organize your work over the course of a year, but I recommend that you turn to this. There's no perfect time to take up rulemaking, but as you can see from the dates, it hasn't been done in many, many years on some important topics.
Thank you, Emily. Are there any comments? Are there comments? Yes. Kim.
Do we, I can't recall, I'm sure we have it in previous messages to the legislature about which rules we were thinking remain in our purview and which we, even just that common set that was in the middle that we all kind of agreed weren't ours. I know that there was some difference on the ends about what pieces were the agencies and what pieces were the boards, but I'm wondering if we might have or take a look at that point particularly. Yes. I would hate for us to spend any time on things that is agreed should not necessarily be ours in the future.
Yes. By the way, are you getting an echo?
I was when you were speaking. I don't hear it now.
Yeah. I apologize for that. I don't know what's causing that. Let me just say that, yes, you will recall, as Kim suggested, that early this year, when we were working toward redefining some of the roles and relationships of the state board and the agency, we felt and conveyed to the Senate that many of the existing rules that are all legally the authority of the state board, that many of them are frankly more management and administrative than they are broad educational policy. And so we recommended that many of the rules, I'll give you an example, school bus idling, probably not a topic that the state board brings a lot of expertise or authority to, that those rules ought to be turned over to the Agency of Education for them to use and modify as they see fit. They seem so much to be more particular or tactical as opposed to strategic. So basically from Rule Series 4000 on, we had recommended that the agency take over those authority and responsibility for those rules. And the agency and we saw differently on the remaining rules that would stay with the board. But the board could probably at least say that from Rule 4000 on, those are very likely to, when things sugar off in this new legislation, those are very likely to be agency-only responsibilities. So that's by way of saying that perhaps the board ought to concentrate its attention on the Rule Series up through Rule Series 3000. And of course, within that group, there's hundreds and hundreds of pages, and so we would need to be setting some priorities about which of those rules we ought to be looking at. I would just mention that in that group of rules that are more appropriately those of the agencies than the boards, one is quite important, is 6400. I'm sorry, not 6400. School buildings. I think it's 6,000. Yeah, it's 6,000. That's probably going to come up again in the next legislative session. That is, there's likely to be a move to return to school construction aid. There was an attempt to do that in the past legislative session, and it got the wheels came off because of COVID-19. that's something that we or the agency should probably attend to, because at the moment, Rule 6000 has the board very, very, very involved in the specifications of buildings, room sizes for different activities, all kinds of things in which we have no expertise. And were that bill to have passed, we would have had to retain outside architectural expertise to guide us on what should be the new standards for how many square feet of the music room for if you have a student body of 300 kids. That's the sort of thing that we know nothing about. Historically, it's been the board's rule, and the board has in fact had to promulgate these new standards. So that's just an aside, which is to say that of all of the rules 4,000 and beyond, that one rule, 6,000, if that's going to become an issue in the next legislative session. So just to conclude, my sense of this is we would be well advised to get started. We are, of course, already started on Rule 2200. We're continuing to work on 2360 and 1300. Those all relating to special education. But that there's no reason to think that we shouldn't get started on the board's own rule itself, 1200. Other considerations in Rule 2200. Earlier this morning we talked about post-secondary education. That is in Rule 2200. I think Kathy, you have begun to gather people's availability. Is that right?
I sent the document. I've only heard from Bill.
Okay, and I think, okay. So if you would all reply to Kathy, Kathy, am I right in thinking that your purpose was to see if we could put together some working committees of the board, and that their purpose would be to take up pieces of the rules?
That's right. That or any other thing that we may come across, but just to get a general feel, and I'll consolidate them and try to find groups that match, of course.
Yeah, I would think, yes, Jennifer.
I don't believe I received that email, or would you be able to resend it, please?
Yes.
Yeah. And,
thank you.
And it's possible then that Angelita did not receive it as well. And Kim has sent you a note saying, please use my proper address.
Yes, I saw that one.
And I think in that I actually did respond to Kathy, so I'm not sure.
Okay.
But I'll look.
So the thought would be that if we could have 2 or 3 working groups of 3 members each, I would say if you'll volunteer to serve on a group, you get to choose what rule you want to dig into. And of course, you would be preparing a proposal for consideration by the board. You wouldn't be acting unilaterally, but you would be a committee of the board, and you would. So if we can get some groups together and some expressions of interest by those groups, Kathy, will you keep pushing on that? And ideally, each group would say, all right, we'll take on this rule set. We'll start doing the hard work of updating that. Then we would connect each, or we would just make sure that we're not duplicating one another and that we're focusing on the most important things. And basically, I would encourage people to be thinking about the rules up to, but not including, up through, if you will, up through 3,000. The rules after that almost certainly will go to the Agency of Education. And so there's plenty to do here and not be intruding upon territory that is more appropriately the agency. Comments or questions? Yes, Kim.
Just looking quickly at like specifically 4,000, and if the agency were looking at those, or if that is something that's looked at, it begs and lends itself to looking through a lens of equity, and it might be different than had been viewed or considered with rules that were crafted back in 2010. So I think there's a different awareness and sensitivity around things like discipline and the language used in crafting those rules. So whether or not that appropriately, inappropriately is on our plate or somebody else's, the agency's plate, I would just imagine that discipline in particular would be something that would benefit from a review, whether it be ours or theirs.
Yeah. It had been the consensus of the agency and the board in its work this spring that would be an agency rule. But I think your comment in general applies generally, and that it's something that anybody, whether it's the agency or the board or committee of the board, that I think we want to have an enhanced consciousness about equity and inclusivity, and the language we use in our rules that would be respectful of those concerns. Emily, you had something to add.
Thank you. And it's a recommendation on the process that you might use, a recommendation only. I've just thought a lot about how this work would unfold over the next 2 or 3 years, because it does take a long time to go through rulemaking, and also about the increased need of staff support. So you mentioned, Mr. Chair, several committees taking up possible revisions to rules simultaneously. If I could recommend that you actually take the work up sequentially, because it is a huge drain on your time as well. Each step in the rulemaking process is very meeting intensive, and I can't imagine that you want to have more than 2 rule series open at the same time, just thinking on how much it would eat up your meeting time. But also thinking about staff support. So I have Donna Russo-Savage, who's happy to help. I don't know that any attorney could work on more than 1 rule series at a time and give you all the research and drafting support that you need. What I had envisioned is that the committee, there's one rulemaking committee, and its first task is to make a list of priorities to recommend to the full board. The starting place, which rules are most urgent, and an order to take them up. And then if that's approved by the board, to start with step 1, whichever rule series comes first.
That seems like a good recommendation, doesn't it?
Yes, I would agree.
All right. Thank you for throttling back my rambunctious enthusiasm about this. I'm sure you're wise to make that recommendation. So we will, Kathy, let's just keep pushing forward, and with some luck, you'll put together a committee of 3 members who will agree to serve in this capacity. Good. Any other thoughts, comments? Have we lost Angelita? Angelita, are you with us? I wonder. Oh, there you are. Okay. Didn't know you were there. And we will presumably Sabina will be back with us when her class in advanced calculus or whatever it is over. Very good, board. We are so productive today that we're now way ahead of schedule. Our plan had been that we would stop at 12:30 for lunch. My recommendation is that we now break for lunch, and that it will be a longer period. The reason I make that recommendation is that there's actually no point in getting ahead of our schedule, because we are obliged to conduct our hearing at 2 o'clock. We can't change the time on people. The public are calling in at 2 o'clock for our public hearing. So I'm expecting then that if we resume at 1 o'clock, we will pick up item J, which is work plan, and Kim will have a report for us on implicit bias training, and there may be other topics. And then we've got 15 minutes allowed for that. Then at 1:15, the Emily Simmons show will resume, and she will talk with us about the issues and themes that have emerged from our hearing so far on 1300 and 2360, which will be a great preparation for what happens at 2 o'clock, which is the public hearing. So with all of that said, then welcome back, Bill. With all of that said, then let us recess until 1 p.m. sharp, at which point we will resume our work. Long lunch. So, board members, we are at item J, which will, Kim is going to speak to us about one part of that, and then we'll continue with the Emily Simmons show about sort of her compilation of themes or major issues that we've heard about with regard to Rule Series 1300 and 2360. And then we will have a public hearing starting at 2 promptly. And I would just mention that if there are a lot of people who wish to speak, and if the public hearing is going to go beyond the targeted end time of 3 o'clock, those of you who need to get off are welcome to. I will stay on, and if one or two other board members are able to stay on, just as a courtesy to folks who want to be heard, that's always nice. But I do understand that some of you may have a hard stop at 3 o'clock. So let us begin now with item J. Kim, talk to us, please, about what you've learned and what you recommend.
Not unmuted, sorry. In looking to get some support for our own board learning together around implicit bias, I spoke a little bit more with John to sort of be clear about what we're looking for. And in understanding at least this being the start of it, focusing on implicit bias as our collective learning, and then seeing where it maybe perhaps goes from there in a broader frame around equity, but knowing that this is the scope of this process to focus on implicit bias training. I checked in with Dan, and he was able to provide a couple of state human resources modules that are possibly an option, but in looking at them, they're really about implicit bias in the workforce and didn't seem to be as targeted to what I thought would have most benefit our board as the proposals that I shared with you all, and I think Suzanne sent them out, from Sue McCormick from Creative Discourse and from Amanda Garces from the Human Rights Commission, the Vermont Human Rights Commission. I had fairly extensive conversations with both of them and feel both would do an excellent job. The cost, did folks have a chance to look through both proposals? Okay, good. The cost for the option through Creative Discourse is $4,000. And there's no particular cost other than donation with a recommended minimum of $200 for the programming offered through Amanda. There she is recommending either two 2-hour sessions or a longer 4-hour session, and I think the scope of what they could each offer was provided in the offering from Creative Discourse. It would be 2 folks teaming on their training with us. I guess I'll just open it to any questions. I feel like both that I'm bringing forward to you will be a wonderful place for us to begin our learning in this area. And I think both would do a good job. I've been part of trainings with Sue McCormick in creative discourse and can speak firsthand to the quality of those programs in a number of different arenas. And I haven't had the same personal experience with Amanda, but I gathered from our couple of conversations that this work is at the heart of what they do. So I imagine they too would do a great job. Any questions, folks? They were both willing to consider in person. Amanda had originally sent if not more than 10 people, and then said that she could consider it, if we were a few more people than that. They have been both delivering this type of training around the state and doing so remotely and using very effectively. One of those that I was part of was done remotely, and they, for parts of the conversation, you're put into breakout rooms, you come back, you share out. They were on a Zoom platform, so it's a little more user-friendly perhaps than this one, but I don't doubt their ability to deliver this remotely. And I think we'd have to think about the sentiment of the board and the guidance provided from the state on if we were to consider doing anything in person. I just offer that. Thoughts, questions, feedback? And Bill had shared with me information from a session they were doing down in his school district, and I've seen that person present as well. I wasn't able to join the link that Bill had sent me just for a conflict in my schedule. So I just wanted to acknowledge, Bill, thank you very much for sharing that resource. That gentleman's really very good. He's from out of state, so I thought I would start with folks in state.
I would say that it was a very successful kind of evening, and the folks were engaged and on target, and actually, to tell you the truth, it got better reviews than I thought it was at first, but it worked.
Awesome. Thanks, Bill. John, I think you're muted.
I'm not. I was just waiting.
No, I think John was muted. It looked like he was talking.
Oh. Well, thank you for pulling these together. I personally don't feel like I could really make a decision between either one of them because they both look equally good. I mean, the biggest difference to me is the cost. But I feel like both of them have an awful lot that they could offer to us. So thank you.
Thank you. I would just note that in the case of the creative discourse folks, they make the point that we would like to stress that the process of understanding and mitigating implicit bias requires a long-term commitment and cannot be addressed in a meaningful way through a single training. Now, I'm not qualified to agree or disagree with that, but that seems to be in sort of a perspective in considerable contrast to Ms. Garza's view, which seems to frame it as we would do it in 2 sessions, and there's no suggestion there that that would just be the beginning of something. I guess at least for starters, my inclination is to want to do this training, have us all do it together, which focuses on implicit bias that we ourselves carry rather than to see it, I'd like to get that first part done. And then if the group then feels that upon reflection, we want to look at broader equity issues or inclusiveness issues or others that perhaps we've become, as a result, more sensitive to, that to me would be a second stage in this undertaking. But I did want to sort of emphasize that what I'm proposing we do is to do kind of the classic implicit bias training, which is intended essentially to help us get in touch with our own implicit biases, of course. And I've done a training such as this in the past and found it provocative and useful. I think it was done perhaps not by Amanda, but by the human resources people, and was provided to employees of the state agency of education, and it was quite useful and thought provoking. And I think as I've said before, I think it'd be wonderful if we do this together. We talk with each other about our experiences and our perceptions, and I think it'll help us grow as a group. So, is there a like Jennifer? I note the rather extraordinary price differences. $4,000 seems like a lot of money for two people for a morning, or whatever. But
I think just pointing out and not defensively of any of it, both consultants, as I spoke with them, and I actually had the chance to speak with both Sue and Nadia, and Amanda, recognize these as tools to start a process. So Amanda may not have spoken to it explicitly, but as opposed to checking a box for having just done it, they recognize it sort of opens up more questions. And I think that's where Amanda was offering the two-hour sessions as sort of a recognition that this learning is continuous and this is a place to start. And I think the donation for the Human Rights Commission helps them provide free training in communities. So we would think about it perhaps not being a $200 investment. I would encourage us to think about it more aligned with the value we would derive from it, and the 3 hours or otherwise for the two people is just the piece they spend with us, the planning. In both cases, they both sets of consultants indicated an interest in doing some pre-work and better understanding our board, and so that they could come in and really tailor our learning to what we need from it. So there would be a little bit of pre-work there, which I'd be happy to do on behalf of us, or you all could let me know how I can further support whatever we decide coming out of this.
But I'd also add that Amanda works for the Human Rights Commission, right? So it's part of an extension of her position. Susan and Nadia, this is their business.
That's
so
right.
It's a different scale in terms of fees based on.
Yeah, and I will say I let each of them know I was speaking with the other and seeking proposals, and Amanda was very quick to say, I hate to take business away from practitioners in this field. And I said, I just know personally as well that Sue is quite busy. So I didn't want Amanda I said, I need to be able to bring more than one proposal so our board can evaluate this. I don't feel as though if I had not felt that Amanda's work was going to deepen our understanding of each other in this area, I wouldn't have felt like I had to necessarily bring you something to check a box and having more than one. So do know that I felt comfortable with the conversations. Amanda said that her delay in getting materials to me, or even this proposal to me, was that they are reworking their modules right now in light of a lot of things, and are encouraged to be doing work and hopeful that for no one when they're doing this work is it just about checking a box. So again, I feel really comfortable with both. I appreciate the note, Jenna, on the difference in how they are pricing these things, and I thought Amanda was really gracious and quick to actually say, oh, I don't want to be taking business away. And Sue was well aware that I was seeking additional proposals. So.
I would also note that if I recall correctly, Amanda is co-chair of the Ethics Studies Commission, and we'll be hearing from her, I think, in January or so. Before long, we'll be having more communication with that group. How would you feel about this proposal? How would you feel that if we retained Amanda to provide the 2 sessions she speaks of and make a contribution of $1,000 to the Human Rights Commission as sort of a courtesy recompense? What would you think about doing that?
I see Bill's hand up, John. I'm sorry.
Oh, thank you. Yes,
I don't know if it's an old hand, but.
Bill, do you have something you wish to say?
Yeah, it's kind of rambly, but fortunately it's short. The one thing that I really made a career mistake on was not being a platform speaker, and Dan can probably speak to this as well, is these guys were paid a lot of money to give presentations, and it seems like we should be able to skin this cat a little bit cheaper than what they're charging for these things. But when we're talking about implicit bias, there's several things that never get looked at, but are implicit to our system. Pre-K sorts kids out. Your classroom assignments sort kids out. Gifted and talented programs, the same thing. Tracking the access to higher education. All of these things are part of our system that we've grown to accept, but they have the effect of discriminating against a group of students. And so that's something I think we need to look at if we go down this path. And Dan, one thing that I've noticed is this use of pods with the virus, in which groups of parents and kids would get together, and they have tremendous potential for being very discriminatory in their composition. And I think that's an issue we need to look at.
I guess, if it's okay, John, I think that is an area of my keen interest, that while we will learn about our own biases, I hope that it is to the end that we see how it impacts the decisions and the work of education in the state of Vermont. And so I think Sue spoke to it in a more extensive proposal, and I think that I understood in my conversation with Amanda that second session would really look at how the biases that we or our systems have impact our work. And so, I think in Amanda's, they just didn't have links that she could send me that were more extensive. And being in the middle of that work, I think we could ask her to tailor our learning to that type of deeper understanding of the broader systemic issues. So my hope would be that is part of what we do with this work, whether it's in 2-hour sessions, or we were to do 3 and ask Sue to lean in that direction. The trainings I've had with her have had pre-work, and I believe also Amanda would similarly invite us to have done some homework going into the work together.
Mm-hmm. Other thoughts or comments? Bill, your hand is still up. Do you want to? Other comments or questions? And do you have a response then to my proposal?
I think you should float it in some fashion and see if we can negotiate somewhere.
Well, Bill, I think that the if it's okay, John,
sure.
With Amanda's proposal, if we felt strongly we wanted to go with Sue, I can certainly go back to her and ask if there's any flexibility in the pricing. If we feel comfortable and leaning in the direction of 2 2-hour sessions and working with Amanda, it is it's a minimum donation of $200. So certainly offering $1,000 either for each session or $1,000 for 2 sessions is clearing that minimum. So I just wanted to clear that up for you, Bill.
Okay.
I think I would just add that it's tempting to sort of skip ahead to kind of institutional bias issues of the sort that Bill just described. But I think that the first work is to look at bias in oneself. And that's uncomfortable. And most of us think, oh, well, I don't have biases. But the training that I've done with these folks was about ourselves, not about out there, somewhere else. It's about what we bring. And I think it's really useful to press up against our own unconscious prejudices before we then presume to have opinions about how others are organizing their institutions. And it's not to say that the questions Bill is raising aren't important. That is, in fact, really central to the work of this board. It ought to be. But this starts out, I think, and I like the idea of 2 separate sessions. One, hopefully the first one being asking us to each, whether in private or among one another, discover what we bring with us by way of bias. And then in the second session, presumably, to move on to and how do we see bias out in the landscape of educational institutions that we deal with. So I just want to, while I applaud wanting to look outside, I think that I would advocate that we that's the easy part. The hard part is looking inside. So, if there's no further comment, then Kim, I would ask you to follow up with Amanda. I had in mind $1,000 a total contribution to make. If others think it should be more or less, please say so. Yes, Oliver.
And perhaps we could just put some sort of a little contingency on this, that we should review the state bidding requirements to find out if we're triggering any need for bidding, and because the limits are actually pretty small, so this even $1,000 might trigger that. I honestly don't know.
Okay, Kim, will you pursue that question and
yeah. Can I just ask Dan or whomever? I'm just not even sure who to check with on that.
Yeah, we started an investigation on this as soon as you started talking about it today.
As soon as I reached out to Dan, he was like, "Oh, it's on
big
this."
spending board members, yeah. Well, what did you learn?
We haven't learned anything yet, but it sort of falls between a gray area, so we're going to look into it for you.
Oliver, thank you for that suggestion, and Kim, if you'll stay in touch with Dan about that. And if you hit a roadblock, well, come back to us. Otherwise, try to move forward.
Okay, and Ken, one thing I wonder, if we're trying to schedule 2 2-hour sessions, if we are able to consider I'm going to ask her what her schedule availability might be. And I know that Kathy was inquiring of us our availability outside of board meeting time. I'm wondering if we're doing this in 2-hour blocks, if we might consider, as we would if we were doing like a retreat, like try and condense our board work agenda to part of the day, break for lunch, and come back. The learning should not need to be, this type of learning I don't think benefits from being recorded and blasted out on RETN. I think we have to be in a space to be comfortable to learn together. And I believe when we've done retreats in the past, that part of the day has not been recorded. Am I getting that right?
That is correct.
Okay, so I might ask us to consider that in the interest of scheduling and finding time that works for people. We seem to make these board meeting days work, and if they happen to be a little bit longer, and maybe something like that.
I think that's fine, Kim. I could imagine doing perhaps December and January or something like that.
Okay.
If not January, then certainly by February.
Do you think it's worth looking at November, December?
Well,
if we handle the other piece in a special meeting, possibly.
Yes, and it might matter to Amanda also.
Yep, absolutely.
So let's stay open to any one of the next 4 months, or any 2 of the next 4 months. And I like your idea of there being a break for lunch or some essentially adjournment of the public meeting.
That's right.
And then we go into a separate Zoom that is private, or a team meeting, or whatever, that is private. It's just us board members and the leader.
Wonderful. And I'm assuming I'm not hearing any particular leaning into needing to do it in person. Or is everybody okay with us doing this remotely? I know Amanda is most preferable for that method.
I agree. I think it's a big deal.
Okay.
These kind of things are so much better face-to-face, but not these days.
I know. Thank you. Okay, great. I appreciate the direction.
Are you okay? Oliver, your hand is up. Okay, take your hand down then. Very good. Thank you for that, Kim. Thanks for all the work you've done.
You're welcome. Thank you, guys.
Pushing forward on this. This now brings us to item K, and we've got 30 minutes for item K, which is a continuation of theme discussion. I think I'm looking for Emily. Emily, oh, there you are, right on cue. I also see some folks from the independent schools team online. Do they need to have our attention? I see Pat Pellis-Gray and Deb Ormsby queued up.
I don't believe so.
Okay. Maybe they just enjoy soap operas. So Emily, we're at your disposal.
Hello, it's the Emily Simmons Show again. I like that term, but it pressures me to really bring the razzle dazzle. At this point, we're looking at another memo that I wrote for you, and its subject is public comment on proposed revisions to Rule Series 2360 and 1300. The folks have that in front of them. Okay, it's also posted on the web for this agenda item. So this was my effort to do what you asked me to in regard to putting a little more analysis on top of that chart where I have been tracking each individual public comment and summarizing it based on what I read or hear. So you have 11 instances of public comment. Those are mostly humans, but there are a couple of organizations in there in the mix. And in these quick bullets on the first page, I've just laid out, to the extent there is any, the pro and con and where the numbers fall on those pro and cons. Now, please remember and understand that the rulemaking process and the public comment process is not a competition of numbers. It doesn't break down to the equivalent of voting. And a public body that receives comment on its rules can go with the minority view that is perfectly legal, but you might find it persuasive, for instance, to know the majority opinion of those 11 people or 11 entities that have given public comment. I don't think Dr. Wendy Geller would approve of this as an appropriate sample size, 11 people for the whole state, but that's what we have right now. 11 entities or individuals who've taken the time to write or speak to you. So by far, the most interesting apparent issue to those individuals and entities is the adverse effect rule in our 2360 series. I don't want to be responsible for telling you what adverse effect is, what it means, how it functions, because there are much more qualified specialists at the agency on our student support team who I really encourage you to hear from. But I also don't want to hide the ball. So adverse effect, in very layman's terms, is one of the gates in our rule about identification of students. So a student is referred for evaluation if their student or their teacher or their parent believes there's cause to wonder whether they require special education services. The end result might be that they are eligible for special education services. In order to reach that end result, many gates need to be met. One of them is that the student's disability has an adverse effect on their ability to learn. Many states do not have that as a specific enumerated sort of box that you check when evaluating a student. But the concept of an adverse effect on learning, the connection of a disability and the impact on the student's ability to learn is present in the federal rules. And we have folks at the agency who can tease that out for you more and talk to you about how other states acknowledge that concept in federal special education law. You've heard many comments that Vermont is the only state that uses adverse effect. Based on my reading of the law, I think that goes a little far, but there's something there to discuss, right? I also will just advocate, and this is a point of view of mine, this is not neutral, that in order, before you remove something from regulation, it's prudent to understand why it's there. And the reason that it is there could be the same or it could be different from the reason why many believe it should be removed. And I think you might find value in investigating those different themes. But we have specialized people at the agency who are experts, and that's not Emily Simmons. It's not the Emily Simmons show. You'd want to hear from our state director of special education and her staff on adverse effect. I mean, I would encourage you to. I don't know what you might want to do. Okay. So it does break down to 9 requests so far to just eliminate the rule that has adverse effect as one of the gates. One of the 11 didn't get into adverse effect, and one comment was very specific in opposing that change. The next and almost equally discussed element of the rules is around the parental Yep.
Excuse me, just before you leave that, the one party that was opposed to changing the adverse effect rule was an organization, and I can't remember which organization it was. I just am asking this because it presumably represents a broad point of view in that it's a person speaking for an organization.
Yes, it was the Council of Special Education Administrators.
Oh, yeah, okay. So on the one hand, perhaps advocates of parents and if I recall, this came from the Disability Law Project in part, did it not? This proposal.
Yes.
So what we're seeing is administrators seeing it one way and some advocates and some advocates seeing it a different way. Sort of, it might be users versus administrators or something like that. Not that makes our job any easier by any means.
Right. I believe 7. No, I won't guess. There were multiple parents within the 9 who were advocating to remove adverse effect. There was an attorney who works with parents, and there was the Disability Law Project.
Right.
I'm sorry, which attorney was that?
Greg Van Buiten.
Oh, yeah, okay.
Then the parental consent provisions, there was 5 people talked about that.
Right, that was the next most frequently mentioned change that commenters would like to see. They cited New Hampshire frequently as the example they would like to see Vermont follow. This would essentially change the portion of this is special ed forms in the schools where at an IEP meeting, the presentation of a new IEP or changes to an IEP, a parent is given the chance to consent or not. Apparently in New Hampshire, although I haven't had time to research their rule, the options for the parent are more nuanced than yes or no. They've specifically cited an option to partially agree or to disagree. And then 5, an equal number of commenters have not referenced this rule. And one comment, which was the Council of Special Education Administrators, was opposed and gave reasons why to this change.
Can I ask you a question? With the suggestion that it would allow the parent to consent partially or to disagree, what's the outcome then? Does the parent's decision dictate, or could they be overruled?
I can look into what happens in New Hampshire. I don't know.
Okay. I'm just kind of curious what that does effectively.
Mm-hmm. Again, this is an area I mentioned on the second page of my memo where there are knowledgeable folks in the Agency of Education who could speak to you about this form in practice, more than just the text of the rule, how this works. I'm not sure if they're expert in how it works in New Hampshire, but we can look into that.
It's my hope that at our December meeting we could have at least an hour with Ms. Kelleher and her staff to speak to these very issues from the perspective of the agency, which is, I think, Emily, what you're suggesting on the second page.
Yes.
And we also would, in November, have the second of our 2 public hearings that we have scheduled, or that we've committed to. So that would mean that by the end of November, the board would have taken all of its public testimony on sort of satisfying its obligations under the APA rule with regard to public comment. And then the official public comment period closes at the end of December. And then come January, we would hope to be working with agency staff to be pulling together a final version of the proposed rules, incorporating or not, as the board sees fit, changes that have been recommended during the public comment period. The goal is that by the end of January, if at all possible, we would like to get ourselves to a final rule that would mean that we would have December and January to accomplish that. That's tight, given the holidays and everything, but I think we just need to remember that we're back under the provisions of the APA process starting on January 1, which means you've had your public comment period, make your changes to the final and present a final rule, and the clock is running. So, Emily, do you have more? Did you want to talk about the general comment of supporting the DLP?
Yes, this is a little murkier, and you might need to get more information from DLP. The Disability Law Project has presented to the board a lengthy set of suggestions to the rules. I haven't had occasion yet to go through and write an analysis of that. I think doing so would be pretty time intensive, so I've put it off. But there are many proposals there that have not been highlighted in a specific public comment, written or oral, and so they're not making it into my summary. And as an honest broker, I want to highlight that for you, first of all, that I'm not an employee of the DLP, and I can't represent all of their more nuanced suggestions for you. So note that you are missing some there, but you have the written materials from the Disability Law Project. They've been submitted to the board 2 or 3 times now. And it is that proposal that many of the commenters are picking up as an example, and they're advocating to you that they believe all of the changes in that proposal would be appropriate. That's 3 of the comments are very explicit. Then there's a little bit of in between, like one comment, I believe it was from the Special Education Advisory Committee, endorsed many elements of the DLP proposal, but did not state support, for instance, for one element, this new rule about MTSS. So my 4th bullet is a little squishy. It's to tell you there's a lot there. It hasn't received a lot of airtime because of just the lack of explicit call out. But there's definitely more to dig in there if board members are interested.
Did the special education administrators comment on the DLP proposal?
I know that they did comment on the MTSS rule specifically.
And they did support it?
They did not. I do not believe they supported the MTSS rule.
So the bullet in your summary, one comment did not endorse the DLP proposal in total, but did state support for an MTSS rule.
Thank you for correcting me. That would refer to the Special Education Advisory Committee's comment. I flipped that, but you're right. It's correct in my bullet.
Okay. And you're silent on where the administrators were on this. We can go back and see their testimony. It's written testimony.
I've seen an email that they actually are going to give public comment today as well.
Yes. Yeah. Okay.
And then one of your requests was for me to point out places where you have authority under Act 173 to adopt the proposals and one where you do not. I found a clear example in my last bullet of a place where someone has asked you to do something I don't believe you have the legal authority to do. A commenter disagreed with the block grant, but we are past that decision point. So I'm happy to tell you that's off your plate.
Okay. So board members, you can see from Emily's good work here some things to be listening to when we get into the public hearing. This adverse effect rule, there are seemingly kind of users and practitioners, parents and practitioners who are and their advocates who are supportive of it, and yet the administrators are not. and then the parental consent provisions. We've heard some support for changing those provisions, kind of, you might say, liberalizing them or making them more flexible. And again, the administrators are opposed to that. And then the MTSS has been supported by some, including the advisory committee, and as well as the DLP. We'll have to find out where the administrators go on that. Are there questions on this now for Emily? Bill, your hand is up. You have a question?
Yes. First, if we wanted to talk about special education regs, we'd need to have several hand trucks to carry around the volumes of material and the boxes of them that impact this area. I've never seen anything like it. There are plenty of people with lots of opinions who quote their own area of research to say this is good and this is bad. And then then you get into due process hearings where you have contention, and it is probably the most technical area, and I wouldn't want us to underestimate the amount of time that this is going to take if we're going to review this closely. And then we'd have to make sure that we had a review process that is informed and level-headed. And if we draw on everybody, we're going to have these differences from these different groups that we talked about. So I guess that's just a caution.
Yeah, I hear you about the hand truck, but we've been dealing with that hand truck of work for the agency and the advisory committee. I mean, I think we're fairly close. What remains are these topical issues that Emily has talked about, and my impression is that they represent 10% of the content of the rule changes, and that the other 90% is pretty much settled among the parties. Is that a fair characterization, Emily or Dan? Emily's.
Were you asking Dan or me?
Dan and Emily.
Yeah, I think in terms of the advisory group, what we've seen as a process, I think, yes, between the agency and the advisory group, I think we've reconciled most of our issues. But, once again, you're in essentially a wide open landscape right now, and you're taking testimony from lots of different groups and lots of perspectives.
But thankfully, most of the testimony is clustered around 2 or 3 thematic areas that are discrete, if you will. You could wind up deciding to proceed with the rule as drafted, and you'd have a rule that was a heck of an improvement over and responsive to Act 173. You could adopt some or all of the recommendations that we've received in public hearings, and you would have the same. You'd have a rule that was responsive to Act 173, had a lot of new content in it, had a lot of substantial work done by the advisory committee and the agency. So, yeah, Bill, I agree with you about the hand truck, but I think, frankly, a huge amount of very good work has already been done, and we're just getting, at this point, down to some important thematic areas, not to minimize them, but they are discrete, and I'm pretty sure we can come to consensus on them.
I hope you're.
I'm seeing Kathy's hand up, and then Kim.
Thank you, and Emily, for synthesizing all of that so nicely. When I think about the testimony, I remember some of the things that moved me, and it was very specific to, of course, whomever presented it, what they presented for. testimony to persuade us or convince us. So my question is very technical, and maybe it's for AOE, Suzanne, or Maureen or somebody, but how do I go back if I wanted, now that you've given us that information, how do I trace that back to some testimony that's sitting someplace so that I can trigger my brain again on, that same emotion, that same thing that said, now that makes sense, or whatever. So where do I go to do that? Is it there that's going to be, and wherever it is it going to be easy for me to access as far as knowing where to get it?
Great point.
We're hoping that we've made it easy to access. So in today's materials, you have, again, the Excel spreadsheet that I'm using. It's a SharePoint document. I'm using it even this afternoon to track the public comment. That gives you the date when it was given and whether or not the person or the organization also submitted written comments.
Okay.
Many folks seem to prepare their written comments and then read it to you. When that's the case, you get lucky because you can just go read it and look for the text that you want. Some people have either not submitted written comment and have only delivered their comments to the board during a public hearing session, or they've done both. They've submitted public comment and then they've said additional or different things to you in your meeting. So for that, you'll need to re-watch the segment of your meetings, and they are recorded. They're posted on your web page for the state board. So it might be easiest to go and start with my spreadsheet, find the person's name, let it refresh your memory what they said from my summary, then go to the date of the state board meeting. I've been saving all of the written public comment in the folder that I shared with you for your September meeting. I thought that would be convenient and be ongoing. If you're having trouble accessing that, I can send you a static folder. Just, this is what it is today, if you're having trouble with SharePoint.
Would you do that, please, Emily? Send that as a static
And so board members, but maybe Emily, you could also, or Maureen or Suzanne could just give the board a list, or maybe even links to the 3 preceding public hearings that we had. I think we had 3 back in the late spring. And then this one. So that there will be a total of 5, mostly 1-hour public hearings during which comments were made, during which those emotions you're speaking about were aroused. And if it's possible for links to be made available to the board to be able to find those, and for the new board members, if you can make the time to go back and hear this and see this material, you'll be caught up to speed, at least on the matters that are outstanding. To look at, mind you, that the majority of the changes are contained in about 50 or 60 pages of new rules, which is, if you're having trouble sleeping some evening, would be very handy. But there's a lot of hard and good work done already, about which there is not controversy at this point. All of those issues have been resolved. These sort of remaining issues are in front of you today, and you will be able to hear about them by going back to look at the public hearings. Kim, you have a comment. You have your hand raised. Perhaps you.
Yeah, I'm just wondering, that issue of adverse effect is big, and I am wondering if this is another area where we need our own counsel on that topic. I don't know. It seems to be, very opposite opinions. So I guess Emily, John, Dan, where do we go on that particular issue?
Okay. Well, when you say our own council, there's the advisory group, which is an entity that represents a diverse collection of interests. Then on the other hand, there is the agency, which represents a different perspective.
Well, I was just...
Other entity that you...
If you'll recall, we didn't pay for it, but the multitude of stakeholder groups pooled resources and hired an attorney, from DC or something. Right. So I didn't know if that particular issue seems so split, if not the popularity being on take out adverse effect, but the one leave it in is an administrator. How do we arrive at a resolution on that?
Well, good question. I would submit that that we should, when we're done with our last hearing, if some kind of clarity is not emerging from that and from your looking at things, we could invite at our December meeting maybe the two opposing points of view about this, one of which might be the Disability Law Project people who are advocates for removing adverse effect, and the other being the administrators who who've been quite clear in their opposition to that change, and invite them to come and make their case to the board.
I'm wondering that I think we could do that, and we have heard from both sides in that way. And I think, to Kathy's point, it for different reasons may evoke emotions around it. I would be more interested in trying to arrive at a decision on that based on if it's an important hurdle but it's being handled in different ways in different states, whose responsibility is it to gather that bit of data for us to analyze in the context of making this decision? That's more meaningful to me than each of them restating their positions, frankly. I don't know enough to make a decision on who's right.
Well, the board could seek to retain the FEG, the Federal Education Group, to speak to that issue only, to provide it with a sort of a global perspective, i.e. what's in fact happening in other states and what are the pros and cons of those practices. Is that what you're visualizing, something like that?
I just didn't know if we posed that question and Emily hasn't had an opportunity to, nor is she probably, I just don't know if that's fair to ask of the agency to give us what other states are doing, or if that's we need to pursue that on our own.
I was suggesting not the agency.
No, I hear what you were suggesting. I just didn't know. Do I think that if that isn't information we have from any other sources, objective information on how that area of the law is being handled in other states, then if there's no other way for us to get that information, I think we should engage with outside counsel for that.
It's available. The Education Commission of the states would have a good compilation. And there's probably several other places that we could go to.
Is Bill volunteering?
It's a phone call. That's all it takes.
You know the right people, Mr. Mathis.
Well, I'll call them.
So, Bill, are you volunteering to recruit the Education Commission of the states to give us a written analysis of other states' practices with regards to adverse effect?
Well, I don't know how they would organize it, but they are a good source if you want a issue pamphlet on any given topic. They're pretty good at it. And if not, we could go to other places. The chiefs may have something, for example, and they would be somebody I'd look for. The National Group on Special Education would be a group I would go to.
Are you volunteering to do that, Bill?
Well, I stepped into it, didn't I?
Yes.
Okay.
Thank you.
With the caveat that I told you beforehand that this is a rat's nest to go into.
All we're talking about is adverse effect. We're not trying to reinvent the world here.
I don't have the time to reinvent it, so
right.
Don't worry.
Good. Thank you, Bill. Any further discussion? We should be really getting on to our public hearing momentarily. No further comment. Bill, your hand is still up, so if you don't have a question, take your icon down. Before we leave this topic, I want to give a shout out to Emily Simmons. She has worked really hard on behalf of the board in the last 30 days. I reckon she probably always does, but somehow this time it was much more visible to me than before. She worked really hard on the whole Kernhattan business, on this, and like I said, it's been the Emily Simmons show. Emily and I have had our knock-ons occasionally, and yet she's always remained responsive and has been a source of terrific effort on behalf of the board. So I'd say a little applause wouldn't hurt at all. So very, very well done, Emily. We thank you very much. And Dan, we thank you for making her available to us.
Thank you both.
Thanks. I really appreciate working with the board. You all work hard too.
Thank you. So at this point, the staff can stand down, I think. Well, you can't, Suzanne, but Emily, I think you can stand back and watch what happens. And we're prepared to open our public hearing. As I said to you, board members, please stay with us until 3 o'clock or the last person who wishes to speak, whichever comes sooner. And for those of you who have a hard stop at 3, then we thank you and go your way. And the chair and a few others will stay by to hear the last of any public comments that might be offered. So, Suzanne.
Yes, John.
Yes, ma'am. And thank you also, by the way, for all you've done to make this meeting come together. There was a lot of stuff at the very tail end coming in real fast. And you, as usual, you and Maureen have taken awfully good care of us, and we thank you for that.
You're welcome, John. Thank you.
What do we have by way of a queue of folks who wish to speak?
So at this point, I have one gentleman on the phone, Mr. Richard Smith from North Country Supervisory Union. I know that he is on the line at the moment and ready to speak. He is first in line. I have 2 other people who thought that they may dial in and speak. I don't see that they're called in just yet.
All right, so we have reason to think of at least 3 folks preparing to speak to us. In that case, let's start out with Mr. Smith, and we'll say to you, Mr. Smith, let's make this no more than 10 minutes, and if you're able to make it a little bit less, so much the better. Please introduce yourself and proceed.
Sure. Yeah, I am Richard Smith, Associate Director of Special Services at the North Country Supervisory Union, and also a member of the BCSEA Rules and Regulations Committee.
Help the board understand VCSEA, that's the Special Education Administrators?
Yeah, Vermont Council of Special Education Administrators, the chief organization of special education directors throughout the state of Vermont.
All right, thank you.
So on March, actually back on May 20th, we had submitted as a committee some written comments to the state board regarding the draft rules, both series 1300 and 2360. And then given that the public comment period for the draft rules was extended until December, BCSEA submitted additional supplemental comments. So we're asking that the board please consider both as part of BCSEA's public comment. So BCSEA supports the current draft rules, 1300 and 2360 as proposed by the state board. These rules were developed after more than a year of discussion with the Agency of Education, the census-based funding advisory group, and various stakeholders around the state, including BCSEA. The discussions included input from a number of stakeholders, as well as advisement from that federal education group you mentioned earlier. They're well recognized as a firm with expertise in education, special education funding. And among the recommendations from that federal education group were that we amend the state's definition of special education as reflected in the special education rules to be consistent with IDEA. Also, that we align state policies on the allowable uses of IDEA Part B funds in order to fully align with the federal definitions so we can take full advantage of the Part B's range of spending options.
Just a question on that, Mr. Smith.
Yep.
So is it your statement that the draft rules for 1300 and 2360 properly accommodate the recommendations that FEG made with regard to funding and allowable expenses?
That's correct, and that's why we're fully supporting the draft rules as they are written.
Yep, thank you.
And the FEG had also advised permitting districts to spend state funds on the full range of activities contemplated by Act 173. For example, districts could code their maintenance of effort eligible spending differently from those things that are not eligible for maintenance of effort, and that would allow us to have flexibility in using the funds. Also, the FEG had advised exploring strategies for reducing administrative burdens associated with monitoring and oversight. Beyond that, the current draft rules were drafted with two guiding principles. The first being that the proposed changes should only be those necessary to implement the Act. So the specific charge outlined in Act 173 is, quote, the development of proposed rules to implement this Act, end quote. So the 1300 series draft is a new rule series that specifically addresses special education funding in a census-based funding model. Technical changes were also made to 2360 series to align with the 1300 proposal and to adjust the relevant definition. The BCSCA does not believe that additional rule changes, for example, changes to child find or adverse effect, are required to implement Act 173. The second guiding principle was to ensure alignment with the federal special education regulations. And so Act 173 was designed to strengthen the system of supports for all students. It was not, however, intended to replace or expand entitlements created by federal law. So the approach taken in the development of the current rules was to ensure alignment with federal regulations, not to expand entitlements. So the BCSCA has had opportunity to review proposals crafted by the Disability Law Project, along with proposals provided in public comment by Vermont Family Network and the Special Education Advisory Panel. For instance, it's been proposed that a set of rules governing the school's multi-tiered system of supports, MTSS, be added to the special education rules, specifically a rule that would require schools to develop MTSS policies. And the BCSCA disagrees that there's a need to develop MTSS rules within the special education rules. You know, MTSS is not a path to special education eligibility. It's a framework for general education that includes all children. And existing language in Act 173 certainly requires development of statewide policies and procedures to ensure that districts effectively implement the framework. We also wanted to respond to the...
May I interrupt for a moment? I need to understand better what you just said. So am I right if I summarize by saying that it's the view of the administrators that Act 173, that MTSS is outside the kind of framework of special education, and therefore the rules should not be amended to create the MTSS within the special ed rules? Is that
right? If it was embedded into the special education rules, it might give a false impression that MTSS was really a special education thing, and the special educators will implement it, as opposed to recognizing that MTSS is our entire system.
And so are you saying that if there were rule changes that strengthened or guided MTSS, they ought not to be part of 2360, but they ought to be part of some other rule set?
Exactly, outside of, not limited to special education, but broader than that.
Okay, thank you for that clarification. Well, I'm sure we'll hear from folks about that. Thank you. Sure. Go ahead, please.
Yeah, there was also discussion earlier about adverse effect, and we disagree that eliminating Vermont's definition of adverse effect is necessary to achieve implementation of Act 173. Vermont's current rules are already in alignment with federal special education regulation, which does include the construct of adverse effect. Therefore, Vermont rule could not fully eliminate the construct as was requested. Frequently, the assertion is made that Vermont districts do not uniformly implement the adverse effect portion of the comprehensive evaluation process. And this is not an issue with the rules governing special education eligibility. Rather, It's an issue with the application of the rules. And so oversight of the district compliance with special education rules is the responsibility of the Agency of Education. And we don't believe that a rule change is necessary, but would support a recommendation to the agency to address specific issues of noncompliance.
If there are instances of noncompliance, are those instances of those noncompliances at the hands of special education administrators or some other party?
Well, this was raised by other groups, so I can't speak to specific instances. But
you're suggesting that it's unevenly applied. So who applies it? Special education administrators or some other?
Yeah, so if I could speak to that, we actually completed a 3-hour adverse effect training for all of the special educators at North Country SU just yesterday. So it is our responsibility to provide the training and guidance, oversight, and monitoring within each of our supervisory unions. That assertion was made by, that it's unevenly applied, was made by other groups that are proposing elimination of that requirement. So I want to be clear, it wasn't my assertion, but can certainly recognize that in a state with well over 10,000 special education students and over 200 schools, that there probably are situations where things are not applied consistently, not just with adverse effect, but with most anything. And that becomes a monitoring issue, both at the local level, but then ultimately that the state would address it if it's a widespread issue.
Thank you.
Not throw out the baby with the bathwater to say, there's some inconsistency, therefore let's eliminate something, right, which is required. It's in the federal regulations that adverse effect be considered.
Thank you. We're winding down on your time, sir. Can you bring this to a conclusion?
Well, yeah, I'll just speak more broadly. You had brought up earlier that there were a number of requests out there about time frames and things like that. So saying that if we're reevaluating a student, it should be done within 60 days. So a clock starts ticking. Where if there's an IEP meeting, there should be a new form that the parents sign. And if they don't sign it, you can't go ahead with the IEP. There's a lot of suggestions that would require creating new forms, new procedures, new issues that could be contentious for due process, new requirements that we do training and have more meetings like we had yesterday around adverse effect to make sure everybody's doing things. And I guess we would just suggest that the requirements we already have in place are extensive and sufficient, and to not generate new forms and new timelines and new requirements, because in the end, they will interfere with our ability to focus on what's important, which is devoting our time to improving our instructional practices and implementing that instruction with students, as opposed to ever increasing the procedures and regulations.
Very good. Board members, have you any questions for Mr. Smith? Yes, here's a question from Ms. Gleason. Go right ahead. Go ahead, Kim.
It was more a comment that I think it's 1300 that's new, but 2360 is previously open. So just to make, as I'm sure you're aware, Mr. Smith, once the rules are opened, while the reason for opening the rules was to accommodate Act 173, we have also, I think, the responsibility to recognize the rules open, and there are other pieces of it that may need attention. So I it's not quite as narrowly limited as suggested.
Sure, it's all fair game, right? Once it's open.
Yeah, and we'd probably not be doing our best work if we weren't paying as much attention as we could to the whole thing to try and get it as right as we can right now. It's a big process to open it, so thanks.
Thank you, Kim. Are there other questions or comments before Mr. Smith leaves us? Very good. We thank you, sir, for your... Dan, do you have... No, just...
Right.
Saying hello to Richard.
Hi, Dan. Yeah, we go back a ways. Up in the Northeast Kingdom.
I'll bet.
Sure. Thank you all.
It's a pleasure to have you with us. Thank you very much. Suzanne, do we have any other folks who wish to be heard?
John, it doesn't appear so at this moment.
Alrighty. I think I will be willing to stay on until 3 o'clock in stony silence and isolation, and the rest of you can go if you'd like to. I just feel an obligation to be available in case somebody calls, but it seems a pity to take up your time. You're welcome to stay if you like, but I think it's. I would also entertain a motion to adjourn.
I'll move to adjourn.
It has been unmuted and moved to adjourn. Is there a second?
Oh, wait, actually, we have somebody in the lobby who just showed up.
Oh, good. I don't see the lobby.
I was also just going to ask if Suzanne knew who had indicated they were coming in. So maybe this will clear it.
I think this person that just called in may be someone who wishes to speak.
Wonderful.
So I would withdraw my motion.
Impetuous youth. So Suzanne, see if you can bring them on.
Jennifer? To unmute yourself, you would need to push *6 if you wish to address the board. I believe she just left the meeting. Yes, she left the meeting.
She got to look at us and thought otherwise. So if we have a motion that's been made, withdrawn, and made again to adjourn. Is there a second, and how do you wish to proceed? Is there a second?
Second.
It's been seconded. Are you ready for the question? And if any of you want to stay around, you're welcome to. It's been moved and seconded to adjourn the meeting. Those in favor say aye.
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 Opposed? Hearing none, the meeting is adjourned, and I thank you all. It's been an interesting meeting, and we got a lot done despite being sidetracked a little bit. I have already placed a call to the Attorney General's office, who has been in the past facilitated our retention of an attorney. And so we will hope to move swiftly to bring an attorney on board and get her or him up to speed ASAP. And as soon as we feel that we can see our way to a date, we will let you all know of a date and time. My guess, just guessing, is that it would be at least a 3-hour meeting, special meeting to even just begin the process, however it might unfold. So with that,
I would suggest half a day of 4 hours.
Yeah,
just to be safe.
We'll probably have to map out with the attorney sort of precisely what we intend to achieve, there being obviously several steps.
And the process, I think that's the most important thing for us, is that we have good legal counsel on the parameters of which we move forward, in fairness to all of the parties involved, that we're conducting ourselves in as fair and impartial way as possible.
Understood.
Mr. Chair?
Yes, ma'am.
I did not receive the letter from the lawyer, the legal for the families. Could somebody send that along to me, please?
Yes, Suzanne, we can do that for you.
She did not. I requested it already. She did not get that. So
I was not included in on that email. And if someone was,
I will send it to Suzanne and to you, Kathy. Anybody else not get that? Jennifer, did you get it? And
I got the letter and a phone call.
Okay.
I got the phone call.
Did you get the letter from the attorney for the alleged victims?
I got a phone call as well. I wasn't able to pick up. I was at school or something, I think. But it went to, I heard the voicemail from the attorney.
Did you get the letter?
Email. Mail or email?
Email.
Possibly. I think I kind of go through, and when I see someone from the board is when I really read through the full email. I'll have to check.
I'll send it to you just to be sure. Okay. And anybody else did? Kim, how about you? No, you didn't.
I did receive the letter, but I think what might be helpful is to, and maybe Suzanne could do a clean board distribution list for all of our board emails, and I don't know how we even save that as a group, but I'm sure I can figure that out. I think that I find, again, it's, I think, partially a me problem with having two state of Vermont email addresses for the two different state boards I'm on. Some of my stuff is going to a different email address. That particular email did come to me that included the attachment from that attorney, but I'm wondering if in advance of the next time we meet in special meeting, the entirety of the package related to that topic be sent in a clean board distribution that goes to just our State Board of Ed email addresses.
Right.
That's probably important for a number of reasons, I would bet.
And Kim, I think there's another Kim Gleason as well in state government, which may be part of the problem.
I think what happened was I'm in as Kim Gleason on the Vermont Pension Investment Committee board, and on this board, Kimberly Gleason. And
there's a third, though.
Is there? There's a Kimberly G. Gleason. All of those are me. But somehow when this all got set up, there's been crossover, and at different times it's gone to different emails, and I forward it to this one and try and respond from this one. But I just think it never happens from Suzanne or Maureen. I think it's because among us we have old addresses when we start an email and it pops in. So if we had a clean one that became our group for a full board, that might be helpful.
Excuse me, John. I do have somebody waiting in the lobby that is one of the people that I thought was going to be here to speak at the public comment period.
All right. Before you bring that person on, I'll give you all a chance to disappear yourselves if you wish. Whoever wants to stay, you're most welcome to stay. You're all in? I guess we're all in. Great. Good.
Okay. Thank you.
Take your hands down, by the way. Some of you have got your hands raised still. And let's please bring in the next presenter.
Hi, Stacy. I'm wondering if you wanted to speak to the state board. You'll want to unmute yourself.
Yes.
Okay, thank you.
Good afternoon. Would you introduce yourself, please, to the board?
Sure. My name is Stacy Rice, and I am the Director of Student Services for the Kingdom East School District. I represent the towns of Burke, Concord, Lunenburg, Gilman, Linden, Sutton, Newark, Wheelock, and Sheffield.
Well done. How do you spell your last name, please?
Rice, like the food.
I got it. Thank you, Ms. Rice.
Yes.
We're all ears. It's 2:31 now. If you could stop at 2:40, that would be great.
Okay, I should not take that much time. So I thank you for hearing me. I feel like I'm representing the Northeast, especially Kingdom East School District. We are operating pre-K to 8 schools. We're approximately 1,100 students, and then all of our high schoolers have school choice. And what I wanted you to hear from me is the importance of your board and your committee to recognize the need to listen to the advice from the UVM weighting study. I would just want to give a couple of examples of what could happen if we don't count the weighting study in for our students moving towards Act 173. I would like to say that Kingdom East School District is fully on board with the Vermont MTSS framework. We have already started trainings. We believe in the principles, and we also are studying all of the components and are implementing all of those practices as we speak. I just want to give you some examples of what could potentially happen if you don't pay attention to the weighting study. If I were to take I have 3 specific examples of, I looked at schools in Kingdom East and compared them to other schools in Vermont, and with the same demographics as far as student population and the grade levels that they have. So if I compare, for example, Newark Street School in Newark, Vermont, they have a little over 70 children in their K to 8 school. If I compared that to the Addison Central School District, Bingham Elementary in Cornwall, and I look at their poverty rates, Bingham Elementary School has a poverty rate of 19%. And Newark Street School has a poverty rate of 67%. This is a difference of 48%, which is why I need you to consider the weighting study. Having the monies shared equally would not represent the students in poverty. I have another example. If you look at Linden Town School, approximately, we're doing the best I can with comparisons for your group, a little over 400 students compared to Charlotte Central School. Charlotte has a poverty rate of 8%, and Linden Town School has a poverty rate of 54%. This is a difference of 46% of the students with poverty. And again, asking you to consider the weighting study that UVM did. And one final example before I sign off and let you get back to your work. Lunenburg Gilman, that's a small little school, 135 students, and I compared that to Franklin West, the Grand Isle Folsom Education and Community Center. They have a poverty rate of 10%. In our district is 56%. Again, a difference of 46%. And just asking that you recognize my professional voice as the Director of Student Services. I'm also a taxpayer and live in Vermont. As public comment, that please recognize and consider the UVM weighting study moving forward with Act 173.
Ms. Rice, thank you very much. I see a lot of heads nodding in response to concurrence with the perspective you're bringing. Just so that you are not immensely disappointed with us, the board at the moment is not dealing with the weighting study.
Okay.
This hearing is in connection with special education rule changes that are mandated by Act 173. The weighting study, while I think everybody on the board is eager to see the legislature grapple with its meanings, just as you are, the board at the moment, absent the legislature making changes in funding, the board has no ability to do anything about the weighting study insofar as how funds are allocated or distributed around the state to the various communities. So I say that just by way of saying that it's not that we didn't hear you. We do hear you. It's just that what we're grappling with right now is kind of the rules of engagement for special education funding in the general sense, but not how the money gets allocated per the weighting study. Mm-hmm. And we hope the legislature will take that on. Mm-hmm. As you know, it'll be a new legislature starting January of 2021. Mm-hmm. And we're all eager to see the legislature grapple with the need, the real screaming imperative to reconfigure how funds are distributed around the state to the various districts.
Well, you're very kind to let me ramble on in the wrong meeting.
Yeah, not at all. We love hearing from real people who are dealing with these realities, and so we love to hear from you and just ask your forbearance that at the moment our hands are pretty much tied. We have to wait till the legislature acts before we can then say, all right, here's some rules. Mm-hmm. So
thank you.
Thank you.
I'd like to add to that if I could.
Yes, this is good.
The weighting study is very important, and I do think the legislature is going to look at it. It's one of the first finance studies which has really been honest about how much it takes to educate kids in rural environments and poverty. Mm-hmm. And nobody's done anything like that in the nation. Mm-hmm. And I would love to see something happen with it, but there's this slight financial problem in the state that we're going to have to overcome. Mm-hmm. But as the judge in South Carolina said, just because we have the virus and economic trouble doesn't mean the Constitution doesn't mean what it means. Mm-hmm. So we'll see what happens. As John said, we won't be on the real front lines of that unless asked to, but it's an important issue, and I hope you folks keep advocating.
Thank you for making me feel better.
Thank you, Ms. Rice. Bye.
Bye.
Well, that was worth waiting for. Suzanne, anybody else?
No.
All right. I think it's recess time. I'm going to hang around for another 20 minutes just to be available, and you're welcome to stay and you're welcome to go. Thank you for today's meeting, and I think I'm going to be seeing you before a month is up. Before, I hope. We got to get going on that. Very good. Thank you.
Thank you.
Thank you.
Thank you.
Peace.